morning. You may be seated. Now is the time set for oral argument, which probably doesn't surprise any of you. In regard to cause number 1, CACV 140622, Brian Burnt, B-E-R-N-D-T, a single man versus Arizona Department of Corrections, et al. For your information, these proceedings are being both audio and video recorded, so barring unforeseen problems of a technical nature, which we know nothing about, you can critique yourselves on YouTube in a couple of weeks. Counsel, each side will be entitled to 20 minutes. We would ask that you respect that time period. The timer located on the podium will let you know how much time you have left, and for an appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. We will do our best to avoid taking up all of your time, but it is ultimately up to you to reserve that time. We have reviewed the briefs. We have conferenced the case within the last half hour. So we are well aware of the facts and issues attendant to this argument. You might want to keep that in mind in deciding how to apportion your time and how it would best serve your interest. Counsel, when you come to the podium, I would ask that each of you state your name and who you represent. And with that, counsel, you can begin.
Good morning. I'm Martin Bin. This is my partner, Donna McDaniel, and I represent Mr. Burnt, the appellant in this case. Really, the principal issue in this case is whether or not 381101K applies. And our view is absolutely it does apply. In this case, the Department of Corrections summarily rejected a personnel board recommendation for an 80-hour suspension and determined that it did not need to comply with 381101K. And so we're here today.
So then the argument made that you are here to defend against is the notion that 41783 and 381101 are disassociated from each other. They have no interrelationship.
Yes, and the problem we have is I'll go back. The argument that has been raised by ADC is that, well, these two statutes, there's a conflict between the two statutes. That's the essence of their position. The problem is the plain language of these two statutes allows them to be harmonized, and you can, as one body of law, operate under both of these sections. As I read their brief, the crux of it, again, that's really drilling down, is the concept that, well, under this, I'm going to call it the Personnel Board statute, that's the 41783, the Personnel Board statute and the 381101 statute, that the Personnel Board statute is more specific and that the 381101 is more general, and that's why the specific governs over the general. They've actually got that on its head. The Personnel Board statute applies to all state employees, not just correctional officers, but all state employees who are covered by the personnel rules, i.e., all of them can appeal. But the legislature has chosen over the years to make a special dispensation for law enforcement officers. Included in that are these correctional officers. So what correctional officers receive is, in an appeal, they get the benefits of 381101K. And that's pretty straightforward. The specific statute is 381101K, adding a little bit to the more general statute, which is the Personnel Board statute covering all of the covered employees. But again, I don't think we even need to get there because you can read these statutes together. It's not that one excludes the other, one's bigger than the other. It is the legislature set up a comprehensive framework for covered employees who are law enforcement officers. And that's just the fact of the matter. It's been going on for years, and that's what's in place. It's also established these personnel rules, the appeal rules, and those go back, I think, to the 70s with the Personnel Board. Again, I guess to make clear, the personnel rules are not the exception to 381101. It is 381101 that is the exception that adds the bit to the general rule in the appeal of 41,783 rules. In the end, there is no conflict. These statutes can actually be read together, harmonized, and operate quite well. ADC also raises an argument, and it's sort of the what-if argument, and it's the looking to the another section of covered employees. 381101 covers law enforcement, but that's broken down into correctional officers and post-certified officers. And when personnel reform took place, all post-certified officers go now to a merit commission. It's a law enforcement merit council for their appeals, while the regular correctional officers who aren't post-certified, just like other state employees who are covered, go to the state personnel board. The argument raised in the brief is, well, hey, look at this. The statute was amended by the legislature down the road, and so shouldn't that somehow change what we're doing here? And the answer is no. And it's as long as we're going to look down the road to see what the legislature did to try to ascertain or divine its intent years earlier, I'd like to direct you to Exhibit 5 of the answering brief. And Exhibit 5 is 381106, and it was a subsequent amendment in 2014. And I'd like to draw your Honor's attention actually to the final page at subsection M. And in subsection M, the legislature talks about who this applies to. And they say, this section, and this section includes the part about the appeal and subsection K, this section does not apply to a law enforcement officer who is employed by an agency of the state as an at-will employee. The legislature has specifically said this doesn't apply to at-will employees. Who is covered? The covered employees, the ones who aren't at will, like the correctional officer in this case. And if your honors actually look at the statutes, the 381101 statutes, the legislature has put that little caveat in each section. In 14, the legislature broke up 381101. It was a giant statute, and everyone had been making amendments to it for years, and sort of broke it up and renumbered it. Each renumbered section has that caveat in it of who it applies to. And clearly, the legislature intended this to apply to the covered employees. It's excluding the uncovered. It's fairly self-evident. Finally, I guess the last area I want to address is the Department of Corrections has taken the position now that the director accepted all of the findings and didn't reject them. That's contrary to a position it took below in the Superior Court. I think what we get to now is this court has to find that 381101K applies. If it applies, this director doesn't have unfettered discretion to modify personnel board decisions. He's limited. It has to be arbitrary or without reasonable justification. Other statutes, like the APA, even part of the personnel board that applies to non-correctional officers, allows the agency head unfettered discretion to accept and reject findings of fact in the recommendation. That's not the case here. So when we look at this case, where the director now has to, excuse me, the director can only change what's been done by the personnel board in its fact finding if there's some lack of justification or no reasonable cause to it. It doesn't, in this particular case, if we take the director at his word that he has now accepted all of the findings and all the conclusions of law, but just rejected the recommendation of the discipline of 80 hours, the director still loses. And he loses for this reason. He loses because it's sort of a matter of administrative law where if the discipline is within a range, it's not for us to change it. And in this case, I think they won't dispute it, that 80-hour suspension is certainly within the disciplinary range authorized. having accepted all the findings and all of the facts, the director is hard-pressed to now argue that that 80 hours that's within the range is somehow now arbitrary or without without reasonable justification. He's stuck. In this case, it's a fairly easy one for your honors to decide. In this case, having accepted all the findings, he's bound by it, and there is no reason to leave, somehow expand, somehow go away from the 80 hours because it is within the range. I'm going to reserve the rest of my time.
Counsel, let me ask you before you sit down. ADC has suggested in an alternative that if we accept your argument on the statutory construction that we remand for determination under 381101K. I rather gather some of your response to that as your last minute
Yes.
or two. Is if you set aside for a minute what you assert as sort of judicial estoppel, I think that's how you term it in your briefs, setting that doctrine aside, do you have anything else to add on why, from your perspective, if we adopted your statutory construction approach, that remand would not be required?
I think remand isn't required, particularly here where he's taken the position and setting aside the estoppel. If we take the director at his word that he's accepted all the findings, all the conclusions of law, all that's left that he disputes is the level of discipline. Cases are legion that this level of discipline issue in the administrative area, if the discipline's within the accepted range, we leave it alone. And I think that's where we're at, Judge.
So it can't be arbitrary if it's within the range of things that are not held to be arbitrary.
Yes, and that's where we're going into the other cases, the Juarez case, and it was a Juarez and there were one other Supreme Court precedent that really discusses this. And if the discipline is within the range, it can't be arbitrary. I mean, there are certain exceptions, but I think those aren't relevant here today. If I might just reserve my time.
Thank you.
Thank you.
Good morning. May it please the court. My name is Michelle Kunzman, and I represent the Arizona Department of Corrections. This is a relatively straightforward case. The only issue at hand is the level of discipline. There's no dispute that Burnt had conduct for which discipline needed to be imposed, and the board found that the agency had proven by a preponderance of the evidence that discipline was warranted based on a level 3 neglect of duty horseplay offense. Because Byrne had multiple disciplinary infractions prior to the one that is a subject of this appeal, termination, the originally imposed discipline, was well within the range of the ADC's regulations for conduct for which the board found. Byrne makes no contrary argument that horseplay is not within the range.
But does the department make a contrary argument that this was something other than horseplay? Or is the department truly accepting the underlying findings of the board?
Yes, the department has indicated in its brief that there's no evidence that the director rejected any of the findings of fact. With respect to what was argued earlier in the lower court, that was simply argument in the alternative that the objections that had been filed, which, by the way, the objections were merely information and argument that was pulled from the closing arguments that both sides were permitted to propose. And those objections were just discussion at the lower court by the department to say, look, in the alternative, the appellant had information on why horseplay or, why dishonesty or the other insubordination was something that Byrne engaged in. However, the department is not suggesting that the director, in fact, rejected those, because there's no evidence in the record that the director did. If you look at his letter, all he did was reject the findings. Reject the recommendation.
So it would be fair to say then that at this point the department concedes that the director accepts the findings of the board?
That's correct.
And if he accepts the findings of the board, then the next question I think that follows that is how can you say then under 1101K, he is able to say that the decision was arbitrary without reasonable justification.
Well, first of all, the department doesn't believe that 3811K applies.
Can you make your record on that, please?
Yes. The reason that the department does not believe that 311101K applies is for a couple reasons. First of all, the appellant argues that the plain language of 381101K means that the correctional officers within the state personnel system are covered with under the 381101K statute. However, that is a general statute that applies to all state employers, okay? And it is a statute that applies to all correctional officers. This issue of the 381101 versus...
Before you go further,
Sure.
Will you agree that Burnt fits within the category of one of all correctional officers?
I would agree that he fits within correctional officers, yes.
Okay, go ahead and continue your argument.
But the problem with the argument that was proposed, looking back at the amendments, is that if you look at 41-1830.16, that is one of the statutes that is within the personnel system, that it references what the rights are of covered employees. That was amended in 2013. And the significance of that is that the legislator had intent to modify that statute to include the exact same language that's in 381101K. It did not modify 41-783 that said that there was no reason given and the standard was not the same. So here you have today a standard in 381101K and in 41-1830.16 that says you need to state a reason, director, and it should be only if it's arbitrary or without reasonable justification. As we sit here today, 41-783 does not have that language. So they're inconsistent. And because they're inconsistent, you need to look, based on the case law, you need to look at which is the more recent statute. And if you look at the statutes under the personnel reform, they are more specific. They are more specific. And personnel reform did two things. It vested final decision-making authority in the director, and it also changed specifically the board's ability to look at the proportionality of the discipline. And so part of what we're arguing here is that even if you accept horseplay, and as we said, that there's no evidence that the findings of fact or conclusions of law were actually rejected by the director, if you accept the findings of fact by the board, and that horseplay is only the thing at play, the board acted arbitrary in the first instance by reducing the discipline, which was already within the permissible range. So our argument is that, first of all, 381101 doesn't even apply for the reasons that I stated.
Does 381101 have any application anywhere under your position? Or is it a statutory provision that should have been repealed?
381101 is very, very broad. I mean, 381101 has application to things that are even outside of appeal rights. It talks about polygraphs. It talks about the rights of a law enforcement officer during an internal investigation. So we're not here today to argue that 381101 doesn't have applicability to...
But the portions that, I mean, at least one way to look at this case, and there are many, okay, is that you have three potential statutory provisions that say sort of two things. Two of the provisions say one thing and a third says another. And we're trying to figure out which one of those applies and can those peacefully coexist? Do those displace each other? And the real question, though, and I want to make sure I understand your argument, is for a case like this, do I hear you right in saying that from your perspective, 381101K just would never apply? It would have no application?
381101K, in answering your question, the application particular to Burnt's situation, because he's a covered officer and he is not a law enforcement officer pursuant to 41-1830.16. That statute is amended. If he was a law enforcement officer, then the application of a decision required and arbitrary or without reasonable justification would apply. That's not the situation
But it
here.
would apply for reasons other than 1101K, is what you're saying.
I'm sorry.
the arbitrariness standard would apply for reasons other than 381101K. It would apply because of a different statute.
The Title 42
Well,
provision.
Right.
Certainly, the director does not have unfettered discretion, because an employee has due process rights and can appeal, as Burnt has here, and is still subject to the judicial review administrative decision statutes that have arbitrariness contained within it.
I'm still stuck, though, on this idea that the two statutes are inconsistent. Maybe you can help me with that. It seems that the first clause of subsection K makes pretty clear that it will be displaced where a statute makes the administrative evidentiary hearing the final administrative determination, but not otherwise. That suggests to me a legislative intent to have subsection K work in harmony with other statutes.
Well, before personnel 381101K, before personnel reform, before 2012, did not apply because the director did not have the final say. When personnel reform was enacted, it specifically modified 41783 and 41830 to actually give the director the final say. After that happened, in 2013, the legislature modified 411830, but did not modify 41783. So there was legislative intent there that showed that those two statutes should be treated differently. And even if you were to accept that 381101 applies here and that the director was required to only make a decision, first of all, it's a recommendation. It's a recommendation from the board, not a decision. And that was another specific intent by the legislator, is, like I said, to make sure that the director is the final authority, and the board, by reducing the discipline from termination to a suspension, was actually acting arbitrary, because termination as the original offense was already within the range for horseplay conduct. So by doing so, this isn't a situation where if you had
two things that are within the range, how can either one of them be arbitrary?
Well, there's a full range between, you could impose something more than 80 hours, between 80 hours and termination. I mean, there's a whole range of discipline you can impose. You can impose no discipline, or you can impose something less than what is appealable.
If it's within the range, the judge's question was, if it's within the range, how can either party's determination be then deemed arbitrary?
Well, that's, and the whole, the way that you would determine that is you'd look at whose action are we looking at here. This court is looking at the director's decision, and the director is looking at the personnel board's decision, and the personnel board is looking at what the agency did in the first instance. So in order to determine arbitrariness, you have to work backward to look at what is the very first thing that was decided. The first thing that was decided was the department terminated Burnt. Okay? Now we have the board deciding, okay, we don't agree with the charges, but we agree that Burnt does deserve discipline. So when horseplay was found...
Right, because the board took a different view of the underlying offense, and the director does not now challenge that different view. Doesn't that change the landscape?
Well, it changes the landscape. I agree with that. However, it doesn't mean that the board should have changed the actual discipline, because, as I said, remember, personnel reform took that away from the board. They're not supposed to subjectively look at discipline, and in fact... But
you're saying then that the termination is a fine decision no matter what the underlying charges are, right? The underlying charges changed from a more serious offense to a less serious offense, a change that the director does not now dispute. But that doesn't really matter because the sanction is the same.
That's not what I'm saying.
Okay.
Because there could be a situation where the board would find, for example, in this particular case, if the board had found horseplay and there was no prior offenses, prior disciplinary history, termination would not have been within the range. And so therefore you would have had a situation where the agency had charged the employee with one offense. The board said, no, we're not finding that, but we're finding horseplay. And the board would have then been within their right to say, okay, here's what we propose. But that's not the situation here. The horseplay violation still warranted termination. And so by the board,
What could have warranted termination reasonably within the range, but didn't automatically warrant termination, right?
well, I guess that's the difference between the 381101 that they're arguing applies, because you're talking about looking at restriction on the director's rejection. And by the way, 381101 refers to a decision, and I did argue that in my lower court, and I do think that that has meaning as well, because the specific language in 41783 refers to a recommendation. And if you look at the personnel reform, there were two specific things that changed, significant with respect to a personnel board's decision. Number one, it no longer had the final authority, and number two, that recommendation is not a subjective recommendation. And so if the discipline that was originally imposed is still within the range, then the board should not be substituting its own decision about what level of penalty is appropriate.
What should the board be doing? Should the board be deferential?
Yeah, the board should be deferential, and that's exactly what the intent of the legislature was. And that's why the legislature imposed a recommendation, and a recommendation versus a decision. I mean, the whole intent behind personnel reform was to give heads of agencies more authority to make decisions relative to imposing discipline. And imposing discipline has to do with making judgment call about what's appropriate, and that's exactly what happened in this case.
So that makes the board then really nothing but an advisory body, because ultimately the director can do whatever he wants.
No, that's not accurate, because obviously there still has to be due process, notice, opportunity, and a hearing before the personnel board or administrative law judge. And the board the department still has to prove the facts. The department still has to prove that discipline was warranted.
But doesn't the record in this matter belie that? Mr. Burnt was terminated before he even filed a response to the charge. A letter of termination was sent out, right?
I apologize, I don't.
You talked about the need for due process and the need for a hearing and the need to give him the opportunity to be heard. And yet, according to my reading the record, there was a letter of termination that was issued before he even had a chance to file a response to the charge.
No, that's not accurate, Your Honor.
Okay.
He filed a notice of charges, then the department issued a notice of charges, Burnt issued a response, the department issued a termination letter, and then there was a hearing before a personnel officer.
Thank you.
And the personnel officer issued findings of fact and conclusions of law. The department objected to those findings of fact and conclusions of law by closing argument, basically. And the board determined that the department had proven, beyond a preponderance of the evidence, that Burnt committed horseplay, a level 3 violation significant enough to impose discipline. The fact that termination was still within the range should have been, the decision should have been to leave the discipline in place.
Why is that? Where is the deference that you say the board owes the director written in statute? I mean, it seems a little odd to have a range if you're saying that the board is constrained to defer to a prior decision that occurred even before the evidence was heard.
Well, the range is actually, first of all, the range that we're talking about is a department range and its guidelines, and it is the department that should be owed deference as to the level of discipline, which was the intent of the personnel reform. So the deference owed to the director is twofold. Number one, as I've said, in the personnel reform, and number two, in the fact that the deference is owed to the final decision maker. There's lots of case law that says that you owe the deference to the final decision maker. And since the director is now the final decision maker, that's where the deference is owed.
What's the point of hearing the evidence then?
As I said, the point of the evidence is that there's not unfettered discretion. The department still has to prove that discipline was warranted. The department still had to prove that Burnt warranted discipline. There's a distinction between what is the level of discipline and whether or not discipline was warranted.
Let me ask you, though, and to follow up on that, One way to look at this case may be that going toward the Personnel Board, the appellant was facing a Class 6 under the chart. And let's say it was a third offense, okay? Mandatory dismissal, no discretion, gone. And instead of finding a 6, the Personnel Board, again, one way to look at this, found, no, actually it was a 3. It was horseplay. It wasn't a 6. It was a 3. Well, then there's discretion to apply. It's 80 hours to dismissal. So why would the Personnel Board owe deference when the case changed in a material way from where dismissal was mandatory to, given the reduction in the charge, if you will, from a 6 to a 3, where dismissal became the most serious form of discipline, the most extreme, as opposed to a mandated? Why is deference owed in that context when the charge changes?
Well, and the charge did change in this context as well. If the charge changed in the context, as I think I hear you saying, where the board is imposing something that is less than termination and both are within the range, why should the deference be owed?
Well, and particularly when it's a 6, there was no discretion for the agency to administer. It was dismissal. Whereas when it goes to a 3, again, for a third offense, and I'm not saying the parties concede that this is a third offense, but then there is discretion to apply, but the agency never applied it because they viewed it as a 6 instead of a 3.
Well,
why is there deference owed when it turns from a mandatory discipline to a range of discipline, given that the charge changed?
Okay, well, first of all, let me explain that, again, that the fact that the range indicates that discipline would be warranted doesn't mean that it's mandatory. And
that may reflect because when I see minimum, I think of,
criminal.
That's it.
Exactly, in criminal. And so you keep in mind that is a range that the department has, by its own development, has provided guidelines for supervisors and managers to make decisions about what would be a appropriate level of discipline. But in that particular case that you raised, the director is going to look at the entire record. It's a final relook. And so in that particular case, the director is going to look at the fact that, okay, if I'm agreeing with the findings of fact and the conclusions of law, and all that was proven was horseplay, then termination is not appropriate. But that's not the case here. In this particular case, the director accepted the findings of fact and conclusions of law, but rejected the recommendation. And the judge and the director's decision to do so was proper in this case. And because he had final say, final authority, and because he actually accepted the findings of fact and conclusions of law, the fact that horseplay was within the range in the first instance was within his scope to actually reject the recommendation.
No, go ahead.
Counsel, let me ask you, I asked your counterpart if we found that 381101K did apply here and that the statutes could peacefully coexist, his view on whether a remand, which your brief mentions as an alternative argument, to be sure, had merit, and you heard his response. What's your approach on what remand could accomplish if we found that those two statutes peacefully coexisted on the current state of this record?
Well, I do think that remand would be appropriate in that instance, and it would mean that the director would need to state his reasons for why he is rejecting the recommendation.
If, in fact, he did on remand, right? I mean, I suppose there's a view that the director might not.
Exactly.
And those reasons would have to arise from the record as it currently exists, correct?
Exactly. And that's exactly what the director did in this case. The director accepted the findings of fact and conclusions of law and rejected the recommendation only. That's in the letter that the director gave to the appellant, and that's the only record. We don't know. There's no evidence as to what the director did or did not consider. And as indicated by 41783E, there's no requirement that the director actually indicate what he looked at. So
the director would have to say, I accept the findings of fact and the conclusions of law, but I'm going to tell you why a recommendation that falls within the prescribed range is arbitrary.
If the 381101K applied, that's exactly correct.
Okay. Is there any case that you can cite to suggest that a recommendation that falls within the prescribed range can be arbitrary as a matter of law?
Well, I think that the cases that cited in my brief talk about the fact that deference, which, you know, is what the Superior Court found, deference to the final fact finder, or in this case, the final decision maker, is really where the deference is owed. And so those cases stand for the proposition that his decision to actually reject was proper.
Are there any cases, though, that conclude that a recommendation within the prescribed range is arbitrary? Are there any cases that came out that way?
I think I referenced a case within my brief that actually referred to that, and I believe the Maricopa, I apologize. Maricopa County Sheriff's Office versus Maricopa County Employee Merit System stands for the provision that only in a rare situation can a punishment be found arbitrary when it falls within the permissible range. And so that case stands for the proposition that if it's within the range, then it's not arbitrary. But the point is,
A rare case.
exactly. But the point is that the director found the board's decision arbitrary. That's the point here, is you're looking at what...
We don't know that. I mean, the director rejected it, but I think you're suggesting that if there were a remand, the director would be entitled to show that this is a rare case.
Well, either that, or what I'm suggesting is that because the board actually made a decision to change the level of discipline when it was already within the permissible range was in fact arbitrary. And that's what this case stands for.
Doesn't changing the level of discipline based on the changed offense level have a certain inherent lack of arbitrariness to it? I mean, if changing the offense level doesn't even matter, then it seems like we're wasting a lot of time hearing evidence. It seems that the conclusion that the board makes as to the underlying facts ought to have some necessary relevance to its recommendation.
And they do within the context of whether or not the original discipline was in fact still within the range. And as I mentioned, you know, this isn't a case where the original discipline was outside the range. This is a case where the original discipline was within the range. And, you know, you can also say that 80 hours, why was 80 hours elected versus 160 hours? I mean, so the fact that the final decision maker rejected the 80-hour recommendation should be deferred to because they are the final authority.
Okay. Thank you, counsel.
Thank you.
Touch on two quick issues. The first was, I think Your Honor was asking about how the termination happened and the order. If you look at paragraph 16 of Exhibit 2, which is the hearing officer's finding of fact and conclusions of law, it's pretty clear there that the agency made the decision to dismiss and to proceed with dismissal before it issued its notice of charges.
So the scope of the due process was basically receiving the charge,
Yeah.
and they immediately just determined to dismiss.
Yes.
And whatever followed from that followed.
Yes.
Thank you.
The other area I'd like to touch on quickly, we talked about, and it was in the last bit of discussion here, and it had to do with the similarly situated, the rare occurrence where a discipline that's within the range would be found to be arbitrary. And those are the two cases I couldn't remember earlier, but it's the Juarez and the Harvey cases that were decided together. And in those, I think there's a footnote that discusses how discipline that is within the range might be arbitrary if it's applied somehow differently to similarly situated employees. Our take on it is, for example, employee shows up late and gets 80 hours off, while all other employees show up late and get a letter of reprimand.
So
That
in a
may be-
singular case, you couldn't make a determination of arbitrariness if it's within the range.
I think that's correct, Your Honor.
Did those cases, though, those are special actions decided by the Supreme Court, if I recall correctly, on the same day?
Right.
In a different statutory world, given the changes that we have.
That's right.
But did those cases in that footnote purport to cabinet the rare case? I mean, did they?
No.
That was an example
Yes.
of a rare case.
That's
Is that
right,
fair?
Judge.
Thank you.
That's right. And other than that, if you have any questions, I'd be happy to take them. Otherwise, I have nothing else.
Thank you.
Thank you.
One of the advantages of getting called to oral argument on a day when there's only one oral argument is we can sit here with, all the interest in the world and let you give us everything you've got in your hand. We appreciate it when you're willing to take that extra time with us. I certainly think it helps expand our understanding of the argument. So, counsel, to both of you, thank you very much for your time this morning. We are going to take this matter under advisement at this time. A decision will issue in due course, and thank you very much for your attendance here today.